Clause 3 of the Press Code deals with privacy, dignity and reputation. You will remember that we touched on the constitutional rights to privacy and dignity earlier on. Clause 3.1 states that the media must exercise care and consideration in matters involving the private lives of individuals. The right to privacy may be overridden if public interest demands this. Let's take a moment to consider the applicable law. In terms of the Constitution, we all have a right to privacy. This includes politicians, celebrities, and average Joes. When a journalist invades someone's private space or accesses private information illegally, our courts ask two questions to determine whether this invasion was justified. Question 1 asks whether the subject has a reasonable privacy expectation, and question 2 asks whether infringing that reasonable privacy expectation was justifiable. A reasonable privacy expectation is explained by Johan Retief. He says that a person normally has the right to privacy in her or his home, as well as to private facts such as matters of health, sex and finance. One can also have a legitimate privacy expectation in a public place, for example, during a corner discussion in a tea garden. When it comes to our medical information and HIV status, we all have a reasonable expectation that this information should be kept private. An example of a privacy consideration in court is the case of the late Dr. Mantu Chabalala Msimang. She was the Minister of Health and was outspoken against alcohol abuse. A newspaper gained access to her medical records and published it. The records indicated that she had been using alcohol while in hospital. The court asked firstly whether Chabalala Msimang's expectation that her medical records be kept private was reasonable and found that it was. Secondly, the court asked whether it was in public interest to disregard her privacy rights by publishing her medical details. Because she was the Minister of Health and outspoken against alcohol abuse but had been drinking in hospital, the court found that public interest justified infringing upon her privacy rights. The right to privacy is boosted by laws that govern our news gathering. This includes common law, the POPI Act and the RICA Act. Let's take a look at the RICA Act, voice notes and telephone call recordings. The RICA Act regulates recording of telephone calls. If you are a party to a conversation, you may record it without having informed the other party that you're doing so. In order to legally possess a voice recording of a conversation to which you were a party, to which you were not a party, you at least need one participant to that conversation to consent to your possessing the recording or the voice note. Just to confirm once again, this legalizes your possession of a recording or voice note to which you were not a party. Remember, having an audio clip is one thing. Publishing it is entirely different and is regulated by Clause 1.8 of the Code, which demands that you ask for comment from those incriminated in the voice note or recording. Let's think about the right to privacy and taking photos and videos. If someone is in a public place, they obviously have a diminished, reasonable expectation of privacy. You may generally photograph anyone and anything in a public place. When it comes to minors, parents have certain privacy expectations that are acknowledged by common law. It will be impractical to ask for permission each time you want to take a child's photo. For this reason, a parent or guardian's permission can be given tacitly. If you take a minor's photograph in the presence of their parent or guardian and you are not stopped, this constitutes tacit agreement. Tacit agreement also applies in a semi-private or private setting. If your subjects see you taking photos of them in a semi-public or public place and they do not stop you, that means that you have tacit agreement. Taking photos and videos once again is one thing and publishing is another step. Before publishing any photos or videos that incriminate anyone, get that person's comment. Privacy and the POPI Act will be discussed when we get to Clause 4. Clause 3.2 dictates that the media must respect the privacy and dignity of the bereaved. A policy on death reporting will be introduced during the editors' conference and deal with this requirement in detail. Clause 3.3 states that the subject's right to dignity may be overridden if the public interest demands it. This clause contains the defences to a defamation claim. If you have a copy of Decoding the Code with you, page to clause 3.3. Although the code deals with ethics and defamation law as a legal instrument, the two reflect similar principles and are therefore discussed together. Defamation is the publication of information that tends to lower the subject's esteem in the eyes of others. Defamation can be lawful or unlawful. Unlawful defamation is the unjustifiable publishing of content that, plainly put, makes someone look bad. Lawful defamation is justified publication of such content. There are 5 defences to a defamation claim that render it lawful. The defence of truth and public interest requires the media member to prove that the defamatory statement made was not only true, but also in the public interest. Protected comment is another defence. To be protected, comment must reflect an honestly held opinion that relates to facts in the public interest. Facts and opinion must be clearly distinguishable, and malicious comment will not be protected. Defamation that is part of a fair and balanced court report will be lawful. The same rule applies to parliamentary reporting, council reporting, or reportage on the proceedings of any other quasi-judicial tribunal or forum. The Press Code has an additional defence in clause 3.3.5, which justifies defamation in an article that accurately and impartially reports on a dispute. Clause 3.3.4 states that defamation will be justifiable if it was the result of reasonable journalism. In Decoding the Code on page 33, the reasonableness defence is discussed in more detail. This defence is acknowledged, in other words, in the Press Code as well as in terms of our defamation law. In short, reportage is reasonable when the following is considered carefully. Firstly, the journalist must ask, is this content in public interest, and answer affirmatively before publishing. Secondly, the tone of the reportage is considered. It should not be malicious. Thirdly, credible sources must be used and their comments reflected in the reportage. Fourthly, remember that first-hand sources are very important. 5. Journalists must seek independent corroboration of sources' statements. 6. Consider the so-called hierarchy of sources. Documents like charge sheets, affidavits, and official reports carry considerable weight. Spokesmen are officially mandated and should be consulted. Signed correspondence, letters, emails, SMSs, and even WhatsApp make for good record keeping. Avoid anonymous sources. If you must use anonymous sources, try to have 3 independent, credible sources corroborate allegations before publishing. Rule number 7 is the Odi Alteram Partem rule. Always get comment from whoever is implicated. Number 8 states that we should use language carefully to convey the status of information. Think words like reported, alleged, unconfirmed, accused. And lastly, does the reasonable reader conclude from your report that the journalist had done thorough research and covered all possible angles? If not, you have more work to do.